All right. Well, it's noon, so we'll get going. So today we are going to do the listing contract and the supporting documents to help you guys get ready for when you have a listing appointment and have a good understanding. We'll go through the contract and the main points of the contract, but I also just want you guys to be familiar with a listing packet and what documents you would need to present to the seller and have them sign. So we'll start with that, kind of work backwards and go through the supporting documents first, and then go into the listing contract. I don't know if, or how many of you guys have been through Accelerator yet. The buyer agency agreement, I know you guys go through in depth during Accelerator. The listing contract pretty much mimics a buyer agency agreement. So it's an agreement with the firm, and a lot of the same provisions are within both. So with that, let's get to it. Maybe. There we go.
Yeah,
right,
feel free to chip in with any questions as Steph goes along.
Yes, 100%, always. First, is everyone able to see my screen? It should look like a zip forms.
Yes.
Okay, great. So, so again, just like when you're preparing for an offer or for a buyer agency agreement, you are going to be coming to zip forms to prepare your documents for a listing presentation. You will, and I can start from the beginning, just like when you are creating a packet for an offer. I want to get my screen over here. Just like when you're creating a offer packet, the same way, same process for a listing packet. So, from your transaction screen, you'll go to new.
So
and then,
Steph, I'm not able to see it.
The screen's frozen. Your share screen's frozen.
Shoot. Sharing is paused because your shared window to the front steps share. Let's try this again. Thank you for alerting me.
There we go.
Okay, great. Okay, so when you log into zip forms, again, you're led straight to the transactions tab. You'll hit new. And then instead of doing new offer to purchase, you're going to go to new listing. You'll name your folder. Usually I'm just labeling it by the address. Category, again, residential. And then I just want to alert you guys again that we have templates built in for us already. So you'll go to global residential listing packet and apply this template, and this will give you all of the most common or all of the forms that you need for a listing appointment. Hit save. And then it'll bring you right into the transaction folder. So we'll go to documents. And here you'll see all of the forms that we need. So we've got a residential listing contract, the Addendum S, the real estate condition report, the seller certificate of non-foreign status. We can actually remove this now. I thought this was removed. That used to be a required form. Now the title company will take care of certifying this for you. The KWNS disclosure, this is required. And then there are additional forms in here. Oh, let me go back. Additional forms that you may or may not use. We've got the listing and selling agent visual inspection form. We highly suggest that you guys use this when you're doing your walkthroughs with the seller. When you're on that listing appointment, you're going to be listing the property. Again, it's our duty to walk through the home. And this just is a form for us to use to mark down our observations about a home, and whether or not we see potential defects. This is just an internal form that we would keep for ourselves, but this is also a good spot, again, to track what you see in the house. But once you receive that real estate condition report from a seller, you can go back and compare it to this. So let's say you observed a crack in a foundation that was not disclosed on the real estate condition report. You can go back to the seller and ask them why there is a difference here, and what they know about that crack, just as an example. Focus title authorization to release form. So this is when you'll use this when it's not coming up. Shoot. So when you have an accepted offer on a home and you start the title order process, the title company requires a wet signature on a form to allow the title company to order what's called a mortgage payoff. You may or may not have this signed at the listing appointment, but you will need to have this signed for sure once there is an accepted offer. I think it's best to just get it all done and out of the way at the listing appointment. If I can get you guys, if I can show you what this looks like. There. Here we go. So it is all of the seller's information, their marital status, and then there's a spot here for them to put in the name of their mortgage holder, and then the loan number, and then the customer service number. And again, the title company uses this information to get in touch with the mortgage company who holds their loan to order the payoff. Focus title seller and buyer information sheet. So again, just when there's an accepted offer on the listing, our title company needs this information to help them do their process of ordering the title.
Yeah, I don't know. Sometimes you do. I feel like I don't.
Sometimes I do.
You do. It's just not using the phone.
The listing questionnaire regarding title issues. Again, this could be used to help with the title company. You could give this to the seller and have them fill it out. I don't know that I've ever had a seller fill this out. So to be honest with you, a lot of these questions are also covered on the real estate condition report. So if there is a potential title defect, it could get answered there as well. Then we get into our MLS forms. So if you are going to put the listing in delayed, or if you are going to keep it as an excluded listing, you would need to have these forms also filled out. So this is the authorization to exclude the listing from the MLS. So again, if you're going to do what's called a excluded listing, where we keep it from MLS, the seller needs to make these acknowledgements by initialing after each section, and then sign it. And then we also, as the brokerage, signs it as well. If you are going to delay the listing, which this means eventually it will be in MLS, it's going to be in MLS within the first 48 hours after the home is listed. But this allows us to keep it in what's called delayed, or what I like to also commonly refer it to as a coming soon status, where this allows the seller to, keep getting the house ready up to 21 days. But it also protects us because we have the home under contract, and it allows us to market it to other brokerages, to our own broker, within our own brokerage, of course, to other buyers, But what cannot happen during this time period is showings cannot happen. So, it's in this, again, what I commonly call is coming soon status or delayed status for this period of, any time from 2 days to 21 days. And getting the house ready for market. But again, showings are not happening, but it's allowing us to communicate to everybody that that the listing is coming and will be soon ready for showings. Joni went through all of these different statuses, I believe, in last week's contract training. So please refer to the YouTube channel as well for further information on MLS excluded versus MLS delayed. And then just to let you know that this is here, a protected buyer letter. So, this isn't happening too much these days where listings are expiring and coming off the market. But this is an example of, if we have a listing, it expires, it does not sell during the time of during the term of the contract and our time of listing it, we send out what's called a protected buyer letter, which I'll go over when we go over the listing contract. But any parties who have shown the property during the time that we as the brokerage had it listed, or anyone who wrote an offer, becomes what's called a protected buyer. And if those buyers circle back within the first year after the expiration date, then we as a brokerage are entitled to that commission, because it was partly due to our marketing efforts that could potentially have prompted them to write an offer. If you guys come to an expired listing and need help with this, please see us. Another comment that I want to make is that this training could potentially run over the hour, in which case I would pick up anything that we do not cover in the next contract training, which will be 2 weeks from now. So just a heads up.
Part two,
yeah. Okay, so now we're first going to go over the KW disclosure. So, every brokerage has their own version of this. And this is a form for us to use to disclose our business relationships with other companies that we own or are affiliated with. So for example, Focus Title, we are part owners of that company, and we need to disclose that to all customers and clients of Keller Williams. Whether or not the client or customer takes advantage and uses these companies, we still need to make them aware that we have a business relationship with them. So on here, for example, we've got Focus Title, and then our home warranty company, which is America's Preferred Home Warranty. Then we just get into other disclosures. This is also serves as a CYA for us. Wire fraud, for example, is much more prevalent these days. So we've got a big disclosure notice, big disclosure about it here. When I'm explaining this to a seller or a buyer, I'm just letting them know that, it is more prevalent. We are taking extra precautions when it comes to wire fraud. Any wiring instructions that they may need to receive as a part of the transaction, they will receive it directly from the title companies. And we want to make sure that we are not acting as a pass-through when it comes to delivering wiring instructions. We would never, ever be a part of delivering wiring instructions. And I just want to make sure that's understood and clear. We have been a victim of wire fraud before, and to the tune of hundreds of thousands of dollars. So it's real, and we need to take it seriously. The next thing that I always communicate to a customer and a client is that that they need to independently verify any instructions that they receive. I know that Kathleen is communicating to new agents that, you know, even if once you receive a wiring instructions, once your client receives wiring instructions, to go to Google first and find the phone number to the title company and call that way versus even relying on the phone number that might be given to them on an email. So just take every extra step that you can. This is also serves as an authorization and consent to call form. So the client authorizes the use of the email address of an agent associated with KW in the email delivery section of the offer, and then a consent to call form. So you'll list the client's phone numbers here. I'm usually putting both cell phone numbers in here. Inspections and property condition disclosure. So I'm just going to read through this actually. So we understand for disclosure and obligation to perform a reasonable and diligent inspection of the property and acknowledge that the real estate agent is not an expert with respect to construction techniques or building materials. Keller Williams advises the buyer to conduct an inspection. So we're saying it right here that we definitely recommend and advise a buyer to have an inspection of the property with a third-party Wisconsin registered home inspector. We expressly release, hold harmless, and indemnify Keller Williams from any and ill liability and responsibility regarding the condition, square footage, room dimensions, lot lines. We acknowledge that we have not relied upon any statement or representations by any real estate agent regarding the conditions or occurrences affecting the property or transaction unless such statements or representations are contained in the offer. There's one more point that I want to make here. Keller Williams Walking North Shore does not recommend a third-party inspection service. I want to point that out as well, that when you're going ahead and giving recommendations for home inspectors, that you are giving multiple names to your clients. Just like with any recommendations with, you know, as far as lenders, inspectors, contractors, that we're giving multiple names out to people. But the biggest takeaway from this is that we are definitely recommending home inspections to be happening. Property information disclosure. So just another checkpoint for us to say that most information provided to the buyer originates from the seller or is distributed from third parties and has not been verified for accuracy. A buyer must independently confirm any information which the buyer considers significant. So there are similar disclosures in an offer and in the buyer agency agreements. And then finally, legal advice disclosure. So just another checkpoint for us to say that we are not attorneys, we cannot give legal advice, and that if they have any questions or need to seek legal advice or need to get legal advice, they need to contact an attorney. So again, they're going to initial after each section, and all customers and all clients of Keller Williams signs this. It's not just clients of a transaction, it's customers as well. So a customer in this case would be a FSBO seller or a buyer who is writing an offer on a home and has not entered into a buyer agency agreement with us.
Steph, I have had some questions where how excuse me, how reliable is signing this disclosure for multiple transactions with this person? So maybe they signed one in January because they were buying a house and then they are listing something. Can they still use this signed disclosure, or do they have to sign a new one for each transaction?
I would have them sign a new one for each transaction.
Okay.
Okay. The real estate condition report. So we have gone over this several times in contract training and in team meetings. So again, the real estate condition report, we're not going to go through this in depth, but all sellers in the state of Wisconsin are required to fill out a real estate condition report. This is a state statute. Unless they are exempt from filling out a real estate condition report. If you have a question about a client or a seller who might be exempt, please see us. But your biggest takeaway when it comes to the real estate condition report is that we cannot advise a seller on how to fill this out. This is their opportunity to disclose any defects that they are aware of. And it heads under structural and mechanical defects, environmental defects, wells, septic systems and storage tanks, and then taxes, special assessments and permits, land use. So that title questionnaire, a lot of that stuff is covered here. And then any additional information. So filed any insurance claims, aware of the structure on the property, that is designated as historic, just additional, kind of property related, but not like physical issues with the property. Again, all owners need to fill this out. Another point to make is that in order for this to be considered a completed form, all questions have to be addressed somehow. So, we've had sellers who have missed saying yes or no or NA on a few of the questions. And part of our job with the real estate condition report, we have very few responsibilities when it comes to the real estate condition report, but we as listing agents are able to go through and make sure that every single question has been answered somehow. So that is very important. If you see any questions that are missing, then we need to return it back to the seller and say, can you please answer this question? Okay. Then once they fill it out, they're gonna sign it here. We'll put it in MLS for the potential buyers to view it. And then if an offer is written, the prospective buyer will sign down here, acknowledging receipt and that they've read this. And then they will also incorporate this real estate condition report into their offer to purchase.
Yeah, if you're working with a buyer and they're a little reluctant, they're given this real estate condition report and they're reluctant to put their signature on it, just reassure them all it means is they've acknowledged that they've received it. It doesn't mean they agree with it or, anything other than just, yes, I was given this and here's my signature for that.
Right. Another common question is that, does this mean that they're like accepting quote unquote the
Yeah.
defects? And it does not. It's not what that means. Okay. Next we have the lead-based paint addendum. This is required for all properties built before 1978. Again, another form for the seller to fill out. On lines 10 and 11 is where we'll put the address of the property. Lines 14 and 15 and 19 and 20 is where they will indicate whether or not they have any knowledge of lead-based paint. What's important to understand is that unless a seller has had lead-based paint testing done, they technically do not have knowledge of lead-based paint on the property. Or if they have been, or I'm thinking of thinking of a case where the city has notified them that they have lead-based paint. So if they've been communicated with, or that they have lead-based paint, or they have gone out and had it tested, they do not have knowledge of it. The likelihood of lead-based paint on a property built before 1978 is high, right? But again, they just technically do not have the knowledge of it existing unless they've had it tested. So most commonly we are seeing that on lines 14 and 15, they are saying that they're going to write none there because they do not have knowledge of it. They're going to sign on line 25. And then we as listing agents are going to sign on line 119. This is another form that's going to get picked up by the buyer when they go to write an offer to purchase. And they then will have the opportunity to incorporate a lead-based paint contingency, lead-based paint inspection contingency in their offer if they so choose. So once they receive this lead-based paint disclosure, then they will determine whether or not they want to have a testing contingency, and they will mark on line 147 or 148 whether or not they will have one. So line 147, buyer elects the lead-based paint contingency. Line 148, buyer waives the opportunity for lead-based paint inspection. As buyer's agents, make sure that make sure that you are marking which ones the buyer, which option the buyer wants. Don't just leave it blank. And then on line 158, the buyers will sign. And then as a buyer's agent, you will sign on line 121. Okay. Any questions about that? Any questions about anything so far? Okay. All right. So the listing contract. So this is an agreement with the firm and the seller. So this is between the firm and the seller. This is not between the buyer and the seller. And this allows us to market the home, list the home for the seller. I'll just start from the top. It's an exclusive right to sell, meaning we are given the exclusive right to sell the home, only brokerage who can. They are not to enter into another agreement with another brokerage to also sell the home. So starting on line 1, seller gives the firm the exclusive right to sell the property on the following terms. So on lines 2 to 3 is where we'll put the address. It goes on to indicate that we need to put it in the, so the next field, line 4, is the municipality type. So included in the list price. So here you're going to list any inclusions in the property. All fixtures are included in the home. So we'll go on to define what a fixture is. Actually, I'm thinking of the offer to purchase where it defines fixture. But a fixture, again, is anything attached to the wall, which you should have learned in pre-licensing course, of course. So sorry, anything attached to the home. So in this section 6 through 11, we would identify things not attached in the home that are included. So appliances, any personal property that the seller is willing to leave behind. And then likewise on lines 12 through 14, we would list anything not included in the list price. So I think that those lines are good for pieces in the home where it seems like it could be something that would be included. I always use this example. There's we had a case once where the seller had a bar in a basement that, you know, the way that the room was set up, it just seemed automatic that this bar was going to be included in the home, but it was a removable piece. And they could absolutely take it with them because it was not identified. It wasn't not considered a fixture of the home. Buyers go to final walkthrough and this bar is missing. And there was a dispute about it, of course. But that would have definitely been something that that listing agent would want to put and identify as an exclusion in the MLS data, or make sure that it was something that would be identified in the offer to purchase as well as an exclusion. So, you know, these things are not so black and white as you're touring the home. You know, another big one is mirrors, bathroom mirrors that look like they should be a part of the room, or look like it's, you know, affixed to the wall and it's not.
Rented water softeners are big.
Yeah, rented water softeners, which I think that is something that, yeah, caution on line 15, there's a big caution for us right there. Identify fixtures to be excluded by seller or which are rented and will continue to be owned by the lessor. So make sure when you see a water softener, when you're touring a home, that you make that, ask that question of the seller and put it down as an exclusion. I think that just came up, right, Joni, last week with somebody that we had to buy a water heater.
Right.
Seller had to buy a water
heater. A lot
heater.
of times if the agent has made that mistake, the agent usually ends up buying the water softener.
Yeah.
So the adage used to be, you're really not in real estate selling licensee until you bought your first water softener.
So anything that you have a question about, listen to yourself and ask the question. You know, don't ever make assumptions. Then on line 17 is where you will indicate what the listing price is. Lines 18 through 20 is where you will describe our marketing efforts. So seller is an authorization as well. Seller authorizes and the firm and its agents agree to use reasonable efforts to market the property. Seller agrees that the firm and its agents may market the seller's personal property identified on lines 7 through 11 during the term of the listing, and this marketing may include, and then here, these are the, you know, you're just going to describe how you are going to market the property. So, you know, this could include social media, internet, third-party internet sites, open houses, print material. You know, you can go through and list every single type of marketing effort that will be made. What I see a lot of times, and you know, as you're, you know, when you're going through this listing contract, you know, presumably ahead of this, you have gone through and described how you're going to be marketing the property to the seller as part of your listing presentation. So I see a lot of times agents will just write, you know, J. Schmidt Group marketing plan. You know, as solo agents, you could say Keller Williams and Emily Howland marketing plan, and that would include all of the things that you've described to them. Because one thing we want to caution you of, and I always use this example, is like, if you're going to say open house every Sunday, you have to stick to doing an open house every single Sunday if you write that in that in that line. So make sure that whatever you're including in there is something that you are going to stick to. So print materials, for example, that's another one. You know, if you have identified that you are going to do postcards, new listing postcards in those lines, you have to do them per the contract. So moving on, lines 22, the firm and its agents may advertise the following special financing and incentives offered by the seller. We haven't seen this so much in this market. We haven't needed to, but definitely 12, 14 years ago when it was a buyer's market, we were seeing this a lot where a seller would offer certain incentives to a buyer to help prompt them to write an offer. So that could be, gosh, the thing that I'm mostly, the thing that's coming to mind mostly is actually an incentive for the buyer's agent and offering selling bonuses to buyer brokerages to help a buyer's agent sell that property more because they're giving a bonus incentive. But this could also be closing cost credits. That's another thing. But again, it's not really happening in this market, so I don't want to get too far into it. But if you are trying to get creative with a property that's not selling, see one of us to kind of troubleshoot or just come up with creative ideas that a seller could possibly offer. So, provision for the seller next is seller has a duty to cooperate with the marketing efforts of the firm and its agents. Seller agrees that the firm and its agents may market other properties during the term of this listing. So of course, we have other clients and other listings, and this is not the only property that we are trying to sell and work for. So commission, this is where we address commission, of course. So the firm's commission shall be, and we have this crash printed in here for an option of 8, 7, or 6% plus $295. You are free to erase this. We just feel it's a good idea, kind of helps with like making the conversation about a 6% listing go easier, but we are, again, a full service brokerage. We are encouraging everyone to list it at 6%. And then again, per our independent contractor agreements, you do have leeway between 5 and 6%. So if you or the seller wants to negotiate commission, you are able to go down to 5. So, a lot of, go ahead, Joan.
Well, it's really important to make sure that you communicate with the seller that commissions are negotiable. There's no set commission. 6% is not a set commission. You can't say that because of antitrust. So you have to always say commissions are negotiable. I'll do it for 6, I'll do it for 7, I'll do it for 8. But again, it is your ability to negotiate the top commission that you will earn in this transaction.
Thank you for making that point. Yes. And then we threw in the $295 there as a, it's considered additional commission on these lines, but the reason why we have that there, is because as listing agents in the office, in the brokerage, we are paying a $295 fee back to KW for every listing that we have. So this is to help cover that fee. I have a ton of agents who do not make this a pass through, and they just eat the $295 as a part of their 6% or 7% or 8% commission. But if you want to try and make that a pass through expense, go ahead and do that. I also see a lot of agents, that's the minimum that is charged because of that exact $295 fee that we pay back to Keller Williams. But I see a lot of agents who will actually, I think J. Schmidt Group makes this $695, and they use the $400 difference to help pay, other listing expenses, help pay bonuses to their administrative staff. So you have power to play with this number as well. So just so you know that.
Yeah, just don't ever call it a fee. It
Right.
is a commission.
Right. And then this goes on to describe how a commission is earned. So beginning on line 29, so a seller shall pay the firm's commission, which shall be earned if during the term of the listing, the seller sells or accepts an offer which creates an enforceable contract for the sale of all or any part of the property. Seller grants an option to purchase all or any part of the property. Seller exchanges or enters into a binding exchange agreement on all or any part of the property. A transaction occurs which causes an effective change in ownership or control of all or any part of the property. A ready, willing, and able buyer submits a bona fide written offer to seller or firm for the property at or above the list price and on substantially the same terms set forth in the listing and the current offer to purchase, even if seller does not accept the buyer's offer. And the buyer is ready, willing, and able when the buyer submitting the written offer has the ability to complete the buyer's obligations under the written offer. The firm's commission shall be earned if during the term of the listing, one seller of the property sells, conveys, exchanges, or options as described above, and interest in all or any part of the property to another owner, except by divorce judgment. The one I want to point out here mostly is if we were going to try and enforce I don't want to go down a rabbit hole here. But we have been in a position where if a offer comes through and again, it's higher than the list price or at the list price, and the seller decides not to sell, we have been in a position where we would possibly enforce that and require a seller to still pay us a commission, even though it does not close. But typically, you know, if an offer falls apart, you know, we just don't think it's good business practice to enforce paying commission if something does not close. Come to us if there are any questions about that. But this just describe how a commission is earned, though. So hopefully that wasn't too gray, and it's very gray actually.
Pretty gray.
Yeah. You know, if a property falls apart, if an offer falls apart, and there is a disagreement on if a commission should be paid to the brokerage or not, just come see Joan and I. That's the best thing I can say about that. It's due and payable once earned. The firm's commission is due and payable in full at the earlier of closing or the date set for closing, even if the transaction does not close. So again, it's in those cases where, you know, we might receive an offer at the terms described in the listing contract and the seller decides not to accept it. We've technically earned that commission, and we could enforce that. So next it goes into calculating the commission. Typically it is based off of the accepted offer price and the commission amount, of course, plus whatever additional commission we have stated. Compensation to others. So the firm offers the following commission to cooperating firms. So this is where we communicate how much is going to be given to the buyer's brokerage. So in our market, what is typical is 2.4%. So you'll just list that here.
We've had some attorneys advise, because commission is negotiable on the buyer side too, that we put in a range there instead of just citing 2.4%. So over at my previous company, the lawyers there insisted that we put in a range of 2 to 3%. Again, our commissions being negotiable. generally is always 2.4, but there are situations where we will offer 2, or there's some situations where we can offer more. All right.
Yeah. Okay, then here's a question, Joni. Excuse me. Since we cannot put in a range in MLS, we would still just put the 2.4% in MLS, communicating
Yes.
to the. So I think it's just more, it gives leeway, or gives us, puts us in a better position if we have to have that conversation with the seller.
Well, this is the conversation with the seller saying you have the ability to offer 2 to 3%. But then in MLS, you're going to tell the other brokers what you're going to pay them. So maybe you're going to pay them 3, or maybe you're only going to pay them 2. But with the seller, you've agreed that you have this range of 2 to 3 to offer.
Okay. When we are, and this is just kind of more of a tip, when people are going over this conversation on commission, a lot of times we'll kind of just all lump this in together and just say that and point out right away that that 2.4% is included in that 6% or 7% or 8%. And that helps kind of just to show that this 2.4% is not an extra 2.4% on top of the 6, and it just makes it more palatable, I guess, for sellers. So okay, any questions so far? We're at 12:47. I'm gonna keep going. Okay. Buyer's financial capability. So this is just a statement here saying the firm and its agents are not responsible under the Wisconsin statutes or regulations to qualify a buyer's financial capability. If seller wishes to confirm a buyer's financial capability, seller may negotiate the inclusion of a contingency for financing, proof of funds, or qualification from a lender, sale of the buyer's property, or other confirmation in any offer to purchase or contract. So that will all be addressed in the offer to purchase, but as you know, as listing agents, though, of course, you know, when we're receiving offers, we're making sure we're receiving those pre-approval letters, for example, along with the offer to purchase. Dispute resolution. So the parties understand that if there's a dispute about this listing or an alleged breach, and the parties cannot resolve the dispute by mutual agreement, the parties may consider judicial resolution in a court, or may consider alternative dispute resolution, which may include mediation and binding arbitrations. So if there's, you know, any potential dispute between us and a client, a seller client, you'll come to Joni or I. I'm just gonna have that go straight there. You'll definitely not be trying to handle this yourself and come to us with any questions. Fair housing, seller and the firm and its agents agree that they will not discriminate against any prospective buyer on account of race, color, sex, or sexual orientation as defined in the Wisconsin statutes. You know, we see fair housing on all of our forms. Disclosure to clients. So this now gets into our duties that we owe to clients and customers under Wisconsin law. And then gets into additional duties that we owe as a client of the firm, as the seller is a client of the firm, and then it gets into multiple representation and designated agency. I think that we could get through this in 10 minutes. But I also want to point out that we do have trainings around multiple representation specifically. So if, you know, that we go into much more in depth with, which is on our YouTube channel under the contract training playlist. But I just want to say before I get into this, multiple representation and designated agency is a, whether you're seasoned or a seasoned agent or brand new, it's a very confusing concept. So I just want to say that ahead of time. So next, okay, so disclosure to clients. So under Wisconsin law, brokerage firm and its brokers and salespersons owe certain duties to all parties of the transaction. So the duty to provide brokerage services fairly and honestly, the duty to exercise reasonable skill and care in providing brokerage services to you. This is one that we talk about a lot in our team meetings as well. Just it's really important to us that we are not trying to enter into areas that we are not confident and skilled in. So biggest example is for those new agents and agents who want to get into commercial real estate, you know, so if you guys have questions about you know, taking on a property that is beyond your scope of knowledge, please come see us. We need to make sure that we are exercising or acting responsibly with our clients and not trying to lead them through something that we don't know how to handle. Same goes for properties outside of our market. So we get a lot of questions about selling property up north. You know, that's out of our market. We don't know that market well at all. So under this duty to the public, we need to make sure that we are acting responsibly and referring that up to somebody else, an agent up north. Duty to provide you with accurate information about market conditions within a reasonable time if you request it. Duty to disclose to you in writing certain material adverse facts about a property unless disclosure of the information is prohibited by law. Duty to protect your confidentiality. Duty to safeguard funds. The duty when negotiating to present contract proposals in an objective and unbiased manner and disclose the advantages and disadvantages of the proposals. The next section are the additional duties that we owe to all clients of Keller Williams. So the reason why they are entering into a contract with us to begin with. And this goes for buyer agency agreements as well. Firm or one of its agents will provide at your request information and advice on the real estate matters that affect your transaction. Firm or one of its agents must provide you with all material facts affecting the transactions, not just adverse facts. Firm and its agents will fulfill the obligations under the agency agreement and fulfill your lawful requests. This is a big one here. The firm and its agents will negotiate for you unless you release them from this duty. The firm and its agents will not place their interests ahead of your interests. Firm and its agents will not, unless required by law, give information or advice to other parties who are not the firm's clients. If giving the information or advice is contrary to your interests. So again, you know, this is why they are hiring us to work for them, our ability to negotiate for them, our ability to give them advice, our market knowledge, and why, and why they are hiring a real estate brokerage. So next up, so if you become involved in a transaction in which another party is also the firm's client, a multiple representation relationship could exist and different rules may apply. So multiple representation relationships and designated agencies. So this occurs when, so we've got this listing contract, we've got our seller client and I'm going to use an example. So I've got a listing agreement with my seller. Joni comes along. She is of course, an agent of Keller Williams Realty, and she has a buyer agency agreement with her buyer, and they want to write an offer on my listing. She has a buyer agency agreement. That means that we have a client relationship with that buyer as well. So now we are under a multiple representation scenario, and all parties need to consent to this multiple representation relationship. And there are a number of ways that this can be treated. So A multiple representation relationship exists if a firm has an agency agreement with more than one client, as I just described. If you and the firm's other clients in the transaction consent, the firm may provide services through designated agency, which is one type of multiple representation relationship. In this scenario now, if my seller client consents and Joni's buyer client consents, we are able to provide the same full scope of services to either party and negotiate, give advice to our clients as we normally would if that same offer came from another company, for example. So where this really comes into play, and this is happening all of the time in these bigger brokerages like our own, you know, we expect and hope that we are working with other Keller Williams agents and that they're selling our properties and we're selling theirs. But where this really comes into play is for those other smaller one-man show brokerages where there could be a conflict of interest if the agent is trying to negotiate, give advice, and work for both parties in the transaction. So there's a conflict of interest for the buyer and a conflict of interest for the seller. Again, if we are explaining it well, we need to give them the option of this designated agency, and we will explain to them that if Keller Williams buyer's agent comes along, they're going to be working on behalf of that buyer in the same way that I am working on behalf of you. And we hope that happens. So the clients in the transaction have another option though, if they don't consent to that. In this same scenario, if your clients do not consent to that, we would have without a designated agency relationship. So we would be working in this same scenario as a neutral party, and we cannot give the full scope of our services to our clients if they do not consent to designated agency. So meaning I'm working for my seller, but I'm not able to give them advice or negotiate for them on their behalf. Joni is not able to negotiate or give advice to her buyers, and we're basically just communicating information back and forth. You know, it's really counter to how we would want to operate with our clients. So this is not ideal at all. So if we're explaining it well, all parties should consent to designated agency. The third option is a complete rejection of designated or of multiple representation. And in the case of a seller client, that means that we would be rejecting all buyer clients of Keller Williams Realty, which would isolate or alienate a huge potential buyer pool of people. So that would just not be in our sellers' and best interest to reject multiple representation altogether. So are there questions about that? I want to invite you guys to, I'm going to throw it in chat real quick, actually. Multiple representation is a hard one. Oh, subscriptions.
If you just keep the basics, multiple representation means Keller Williams.
Yes.
Keller Williams on both sides.
Okay, I've got my kiddos. Hang on. Stop share here. it's important for me to get you guys this video, so one second. Gosh, I can't, here we go.
Well, hello, everybody.
Okay. Okay, if you guys want to grab that really quick. This goes through agency and multiple representation more in depth. So we'll continue this on 2 weeks from now. Sorry for the big break. There is, it's Juneteenth Day on Sunday, so the office is closed in observance of that on the 20th. So we will not be having contract training. But also I want to assure you guys, after we go through this contract, we'll also just talk about like kind of the best, you know, we don't want to be going through this line by line with our clients, right? So we'll go through like, you know, the sections that we're going to go through each section, but like be able to kind of give a one-liner about each thing, right? So it's not realistic to go through it line by line as I am doing with you right now with your own clients. So, okay, are there any questions? Also, I would love to encourage you guys to like allow us to see your faces during this. So next time we meet, if you guys are able to, you know, show your videos, that'd be great. Okay.
Thank you, Steph.
Thank you guys.
Thank you.
All right. Have a great week.
Yeah, you too. Thank
Thank
you.
Steph.
Bye.
Okay, bye.